Good morning to those of you joining from out west, and good afternoon to those of you joining from out east. My name is Leslie Fradlin. I'm a partner in our Toronto office in our Labor and Employment Group, and I'm delighted to welcome you today to our spring update on Canadian employment and labor law matters. We have a great agenda ahead of us today. We're going to be touching on relevant topics that we're seeing come out of today's workplace. For those of you who are members of the Law Society of British Columbia or the Law Society of Ontario, we're pleased to be able to say that this seminar has been accredited for 1 hour of substantive content in each of those jurisdictions. To the extent that there are any questions, we encourage them. Please feel free to use the Q&A box that you can see on your screen. We'll be monitoring them throughout the webinar, and then we'll plan to address as many of those questions as we can at the end. Without further ado, I'm going to turn it over to my colleagues, Giovanna and Melinda, to walk us through some updates on artificial intelligence in employment.
Good morning, everyone. Even if you've been living under a rock, you know that AI is everywhere, including under that rock. Of course, it's made its way into the employment relationship. So how are employers using AI? Employers can use AI to streamline, and you might say enhance the hiring process. It can screen resumes because it can be used to analyze large volumes of material based on specified criteria. Chatbots can be used to screen initial candidates, guide them through the application process. You can use AI to analyze candidate responses in both written applications and video interviews, checking for body language and facial expression. There are other applications in the employment context, including workforce data, performance management, market comparisons, providing general information such as best practices, and of course, AI can take on some of the work previously done by employees, not just the HR team. Like any tool, the use of AI comes along with considerations and risks. Firstly, accuracy and completeness. Generative AI has a nasty habit of providing incomplete, inaccurate, or completely made up information, aka hallucinations. It aims to please. So it provides the answers that it expects that you want. It's not capable of sophisticated reasoning, abstractions, conjecture, or common sense. That's the level where we're at, so we need to be mindful in its use. It goes without saying that employers and HR professionals should not rely on made-up content, but also know that AI is not a substitute for human reasoning. Another general risk of AI is that its use may lead to a change in the employment relationship by fundamentally changing the employee's duties. In other words, the employee isn't doing the work, the AI is, and that's not always going to be welcome. It can lead to claims of constructive dismissal, so where possible, seek buy-in and better yet, explicit employee consent. As AI continues in the workplace and the jobs are going to change. There's also a big risk on the human rights front in the use of AI. The trouble is that AI has the potential to discriminate against individuals or groups. And of course, discrimination on protected grounds is prohibited by legislation. The unchecked use of AI could encourage discriminatory outcomes and amplify biases that are already present in hiring and workplace practices. Giovanna is going to discuss how and why in some detail, and it's fascinating. Finally, AI could invite privacy and confidentiality breaches as well, so we need to be careful of our data storage, privacy compliance. So if you're going to use AI, it's important that you understand how it works, what information it's using, its limitations, and the potential for error. Consider the legal implications and the ethical implications. Avoid discriminatory outcomes, and that requires that employers audit the data that's input into the AI. And if you don't know what goes into it, you shouldn't use it. It's not set it and forget it. employers should monitor their AI systems to check for accuracy, privacy, and correct bias. The burden is on the employer and not just the AI system provider to address these risks. There's no defense that it's the AI that is doing the discriminating or causing the problem, and there is some case law precedent for that. Make sure your AI is compliant, and that's not just privacy and human rights. Giovanna will talk about some of the legislation in the pipes. You can, and perhaps you should, use AI where it makes sense for your business. Just make sure that you're managing risks. Ultimately, you may be responsible for what the AI does, and that's certainly what decisions to date have found. This case is a great example of poor use of AI and failure to manage risks. It's not an employment matter, but it's still a great cautionary tale of the limits of AI. So this lawyer used AI to research an issue of law in a custody matter, and ChatGPT made up cases, completely fabricated. She failed to check, and she relied on these made up cases in court. She also failed to provide notice to the court and opposing counsel as soon as she became aware, amplifying the problem. In addition to what she naturally described as mortification, she was liable for costs of the application, as well as other professional consequences. The court cited a 2024 study that found legal hallucinations occurred between 69% of the time with ChatGPT 3.5 and 88% with Llama 2. That's the Facebook or Meta AI for those unfamiliar. Large language models, they fail to correct incorrect legal assumptions, and worse yet, they can't predict, and they don't always know when they're producing legal hallucinations. You can't fix the problem by instructing the AI not to hallucinate. So you need to manage your risks by understanding limitations. Giovanna?
Thanks, Melinda. And to understand why AI does what it does, the weaknesses and risks that Melinda just talked about, it's helpful to back up a little and actually understand what AI is. When most of us think of AI, immediately we might think of Blade Runner or Terminator. And that's not the kind of AI we're talking about here. We're not talking about human-like intelligence or AI that is able to engage in complex thought. That type of AI, which is usually referred to as general or strong AI, is, at least to our knowledge, currently hypothetical. Instead, the type of AI we're talking about when we're discussing legal implications of AI use is narrow or weak AI. For example, ChatGPT, which falls into the subcategory of generative AI, is also narrow or weak AI. What does that mean, and what does weak AI do? All that weak AI does is predict outputs from inputs. AI is nothing but a complex set of algorithms that perform specific tasks, in this case prediction, based on inputs that are provided to the AI, and that it's able to do this based on training the AI has previously been provided with. Let's back up a little bit more. What is an algorithm? An algorithm is nothing more but a step-by-step set of rules or operations. You probably use algorithms in your daily life. If you've ever been able to follow a recipe, well, you followed an algorithm. This is just a more complex version of this, and that's why we can only have limited expectations of what AI can do for us. It's important to understand these limitations of AI because AI can display bias. Algorithms can display bias. You're already familiar with the concept of bias. This is not a new concept. And I would think that current knowledge that you have about bias will serve you well, even navigating the introduction of AI to the workplace. What does it mean to display bias? Well, essentially, you might end up with a biased result where you inadvertently select for one variable that strongly correlates to another variable you're not trying to select for, and that original variable is essentially a proxy. What's a classic example of this? Discrimination, inadvertent discrimination based on prohibited grounds of discrimination. In the same way as we can make that mistake and inadvertently end up with biased outcomes, AI can also make that mistake. If anything, AI is even more liable to make that mistake because AI doesn't have judgment, it doesn't know what's true or false, and it doesn't truly understand what it means to have a bias, to have or generate a biased outcome. It's still up to the human to determine whether bias may be appearing in outcomes that are generated by AI, either due to the data that was used to train the AI, the AI model itself, the prompt that the user provided the AI, or other information that's been provided to the AI, as well as the use of the output of the AI. Next slide. So as you can imagine, using AI can result in some harm. And some of these harms, bias would be a great example of this. Some of these harms are likely to manifest, particularly given the stage at which AI is operating right now. And in response to these potential harms, there has been a bit of a flurry of legislative activity. And anyone who's following this will know that there has been activity in the EU, in the US, and there has also been some legislative activity in Canada. You may already know this, but the federal government introduced Bill C-27, which is a very large piece of legislation that, if eventually passed, it will introduce the Artificial Intelligence and Data Act, which will specifically set out to regulate AI, but it will also make amendments to PIPEDA and to the Canadian Human Rights Act, recognizing that the introduction of AI will have impacts on various areas that include, but are not limited to, privacy and human rights compliance. Even though C-27 is still in the pipes, right now it's at the committee stage, I believe, that doesn't mean that there hasn't already been some guidance and thought putting into how to use AI, since AI is already out there. If you're interested in finding out more, you can access guidance that's been published by the Office of the Privacy Commissioner of Canada, which outlines principles that would be helpful for you to consider when engaging and implementing AI in your workplace. And finally, as you know, in Canada, there is regulation of the workplace, both at the federal and the provincial level, and there's been a little bit of legislative activity at the provincial level. Anyone else on this panel can correct me if I'm wrong, but I believe the only piece of legislation we've seen thus far that directly deals with AI in the workplace is Bill 149, the Working for Workers for Act 2024, which would amend the ESA to introduce 2 new sections that will require employers that advertise a publicly advertised job posting and use AI to either screen, assess, or select applicants to inform the applicants that they are using artificial intelligence. The devil is in the detail, and right now there is very little detail because the definition of artificial intelligence has been left to the regulations, which are yet to be issued, and the scope of the application of these new sections has also been left to the regulations, which are yet to be issued. So we don't know exactly which job postings are going to be affected, which employers may be exempted, and so on and so forth. So all we can say is this is a developing area of law, and it's worth keeping track of it. So that's it for legislative developments. I will now pass it back on to Melinda, who will review next steps for targeting, integrating AI effectively.
This is your takeaway. When you're using AI, be proactive, conduct bias assessment of prospective AI systems, know how it works, be transparent about the use of AI, monitor data storage and privacy protocols, and consult with your legal counsel to ensure you're complying with the rapidly changing legal landscape. We expect quick movement on this. We put up some resources here if you are interested. I'm sure the slide deck can be shared. Thanks so much.
Thanks, Melinda and Giovanna. We will be sharing the slide deck. We'll send it out by email after the webinar today, so you'll be able to have access to those resources. For our next topic, Dana Hooker from our Vancouver office is going to be talking about managing difficult conversations, and specifically with respect to political statements in the workplace, which I think a number of employers have been dealing with these days. Dana, over to you.
Thank you. So good morning and good afternoon, everybody. It's a pleasure to be speaking to you today. And I'm hoping to be able to give you some clarity in navigating what is becoming a very difficult world. This first slide here really was just, a very quick Google search of various media outlets, just shows us all of the various things that people can get riled up about and that can infiltrate workplace discussions. So, we have inflation, we have China, Taiwan, we have Israel, Hamas, we have AI, which we've just discussed. We have our favorite presidential candidate south of the border. All of these issues are creating a lot of workplace strife, and I'm hoping to be able to navigate it for you. But as you can see by my next slide here, it is a bit of a dumpster fire, and we live in a challenging world. So what can we do as employers to keep everybody focused on their work and avoid a lot of internal strife? So on the one hand, Leslie, if you could go back to the previous slide. on the one hand, we've been here before. We saw a lot of challenges in the workplace coming out of the 2016 US election. Our friends south of the border were certainly very affected by the polarization in US politics, but that, of course, has had some spillover effect into us being such a close neighbor. However, we have a lot of other issues that have come up since the 2016 US election, or that have arisen out of some of the politics that have developed that are becoming issues in the workplace, hot button issues. So we, of course, have all lived through a pandemic and vaccinations and mandatory vaccinations. We've lived through supply chain issues leading to massive inflation and interest rate changes. People are under stress. Climate change is getting its due, and it's a daily onslaught of information about how we should be conducting ourselves in respect of climate change. We have increasing tensions with China. The relationship between the West and China is changing, and this has a direct impact on business and how we talk about those relationships in the workplace. We, of course, also have global conflict, including the war in the Ukraine, the Israel-Hamas war. We have some recent issues in Canada regarding political interference by foreign nations. And then, of course, we have another US election coming up, which doesn't seem to be any less fraught than its predecessors. So we have all of this in this mix, this dumpster fire effectively. And we see that the issues are coming into the workplace in a number of ways, largely because of the way we are working now. So opinions are easily, and for better or for worse, widely published and shared. We have employees who are getting on social media, Facebook, Instagram, Twitter, X, Threads, which is a new one, Snapchat, Discord, YouTube, and I'm sure all sorts of other social media platforms that someone of my generation has no idea about, but they're there and they're used. We also have internal communications, which have facilitated quick interaction, particularly between remote workers, but at the same time lend themselves to a casualness where people may feel free to express their opinions. Slack, Teams, and then, of course, email, which has been around for a while. For those of you who are still have folks coming into the workplace, we have the proverbial water cooler, people standing around in social or common areas talking about the world and potentially getting into disputes. And then the issue of hybrid work is an interesting one. Some commentators have pointed out to the fact that employees who, for example, do not use backgrounds, such as we are using here today, may have political posters, images, or other information visible while they are participating in workplace calls that could potentially alienate or cause conflict with their coworkers. So there's lots of ways that the outside world infiltrates our workplace. So the question is, what can we do about it? Now we can move to the next slide, Leslie. So where we need to start, of course, is with the law. How does the law apply to workplace interactions? So firstly, we have occupational health and safety laws, which, as many of you or all of you know, is the regulation of conduct in the workplace. And almost without exception, occupational health and safety laws in Canada mandate that bullying, harassment, and violent behavior are not acceptable in the workplace, and that employers have an obligation to maintain a health and safe workplace, including an obligation to mitigate or eliminate bullying and harassment. So when we have disputes, when people have strongly held political beliefs that are maybe tied up with emotional or other concerns, we nevertheless still need to ensure that all interactions are conducted appropriately. Feeling a profound impact of the Ukraine conflict, for example, does not justify somebody engaging in behavior that would objectively constitute bullying and harassment. And it's important to remember, of course, that under occupational health and safety legislation, there is a very broad concept of what constitutes the workplace, meaning that if the interaction in question between or among employees is sufficiently connected to their employment, it very well falls under the scopes of the employer and the employee's legal obligations with respect to workplace conduct. So again, if people are ganging up on somebody on Facebook because of their political belief, and that activity has a sufficient connection to the workplace, it may well fall under the scope of occupational health and safety laws. And as an employer, you are going to be obliged to investigate and do something about it. So that's an important one to remember. We all have to behave professionally and respectfully amongst our coworkers and our peers. The other issue that employers need to be cognizant of is human rights laws. So there are jurisdictions in Canada that actually protect political belief. So political belief is a protected ground, or we call it prohibited characteristic, meaning that an individual who is subject to an adverse impact, so maybe discipline, termination, harassment by a colleague as a result of their political belief, can potentially file a complaint with the appropriate human rights authority, and that complaint will be adjudicated no differently than a complaint of discrimination on the basis of disability or family status, or race or sex would be adjudicated. So I've prepared a table at the bottom of the slide, just setting out which jurisdictions actually acknowledge political belief or political opinion expressly in their legislation, and the jurisdictions that don't. I've also included a column which I've called political adjacent, because there are often very, very fine lines between the concept of a political belief or a political opinion and somebody's identity, creed, or religion. So, it is not an easy area to navigate. But we've tried to point out here those jurisdictions where you're dealing with somebody who is expressing their political belief, or somebody who is concerned about the expression of political belief, where you may need to be cognizant of your duty to accommodate as an employer. And very briefly, we have jurisdictions like Alberta, for example, which do not recognize political belief. And then we have jurisdictions like Ontario, who do not expressly recognize political belief, and who judicially have determined that political belief should not be read into the protected ground or prohibited ground of creed. We also have BC, which is probably at the furthest end of the spectrum in terms of offering broad protection, where political belief is fairly broadly construed. And then we have jurisdictions like Manitoba, where political belief only extends to belief that has a very focused political object, so not any issue that just affects public well-being. So it's a much more narrow. And then we have Prince Edward Island, which is perhaps the narrowest, where political belief only extends to political parties in the province. So it's a very, very narrow and not expansive view of what political belief is. Leslie, if you could move to the next slide. So how far is too far? So we know that you have to behave properly. You might have some protected speech, but what is too much? And if you flip to the next slide, Leslie, the question is really, looks like there was a slide where, anyway, there was a title slide there that should have said, do employees have the right of free speech? And somehow it got cut. But the answer is no. But, our favorite answer as lawyers is, it depends. So this is one of those it depends situations. So strictly speaking, employees cannot say to you, I'm going to talk about what I want, when I want, and how I want it, because I have freedom of speech. Freedom of speech is an enshrined right under our Canadian Charter of Rights and Freedoms, but this is a right that we exercise as against the government. So as against a private entity, which is an employer, that charter right is not engaged, okay? But we do, of course, as I said in the previous slide, have some human rights protection for certain types of expression, right? So we have our protection of political belief or political opinion in certain jurisdictions to various degrees. Where we get to the grayer and fuzzier areas is that, of course, human rights legislation is considered quasi-constitutional, meaning it is very significant legislation. It is given significant deference, and the interpretation of our charter does, to some degree, infuse the interpretation of human rights legislation. And we do see that in BC in particular. Now, at the end of the day, it's the delicate balance, okay? Even charter rights vis-a-vis the government are subject to reasonable limitations, okay? We see that in concepts of hate speech under the criminal law. Similarly, in the workplace, even where an employee has a human right to political belief or political opinion and to express that belief in certain ways, that right is subject to reasonable limitations. And we can say in the employment context, using human rights speak, we call it that bona fide occupational requirement. It's that justification for why you may want to curtail or need to curtail somebody's expression of this protected belief, because ultimately as an employer, you've got to maintain those safe and healthy workplaces. So how do we do it? Okay, so number one, you need to consider what the test for discrimination is, where political belief is protected. So to establish discrimination, you need to say, I have a protected characteristic. So in BC, you can say, I have a protected characteristic of political belief. In Ontario, the employee is somewhat out of luck in that respect, unless they can establish that their characteristic somehow falls within the scope of another protected characteristic in that province. You need to demonstrate that you have an adverse impact. So I've been disciplined, I've been terminated, I've been harassed by my employees, I've been subject to some kind of negative consequence in the workplace. And then there has to be that nexus. So my political belief, and there was a connection between my political belief and the negative impact. Then the onus shifts to the employer to say, well, that's all well and good, but this is why we have had to do what we did. So effectively justifying what we would call the prima facie discrimination in this case. So how do you justify your curtailing of political speech in the workplace? You're trying to manage that conflict. How do we do that? Leslie, can you flip to the next page? We go back to the beginning. We go back to your obligation as an employer. So look at your policies rather. What is acceptable to your organization? Make sure you're setting expectations. You have a respectful workplace policy, most likely, or you should under occupational health and safety laws. Do you have a non-discrimination policy? Many employers do. This means, of course, protecting both the target of any political speech and the person who's making it where appropriate. Do you have a social media policy? Do you have rules that govern how employees use social media in the workplace or how they can communicate their opinions on social media, particularly where there's a risk that could be imputed to the organization? Following similar policies, acceptable use policies, communications policies. Do you have a policy on solicitations in the workplace? There are, of course, solicitations which are permitted, usually in the labor context, but do you have a policy that says, look, we don't allow people to come and solicit donations, sell Girl Guide cookies, whatever that might be? Do you have a policy that deals with workplace disruptions? And do you have an anti-violence policy? Always rely on those policies. Having a policy doesn't immunize an employer from allegations of discrimination. They, of course, must be applied in a way that is consistent with the code. But when we're talking about trying to establish reasonable limits on discourse in the workplace, this is really where you should start. Then it comes down to creating a workplace culture where people can have difficult conversations without them devolving into something that becomes a distraction from productivity and potentially leading to complaints of bullying, harassment, or discrimination. And that really comes down to training, and it comes down to enforcement and reinforcement of your policies. You can flip to the next slide, Leslie. You need to understand what your policies say. You need to understand what the requirements for a safe workplace are, and you need to have consistent applications. So you need to avoid inherent bias. If you have somebody who says, I don't support the war in Ukraine, I believe that Russia has a right under international law to invade the Ukraine, I mean, you can't react to that person necessarily differently than you would react to the person who says, I fully support Western intervention in that conflict. Okay, you need to avoid value judgments in terms of the opinions that people are expressing, provided that people are expressing them in a way that is, safe, reasonable, and not unduly disruptive to the workplace. Okay, you also need to keep your employees focused on the task at hand. It can be very tempting to what I call ostrich, which is shove your head in the sand and just, we're not going to talk about it in this workplace. We don't talk about political things. We don't talk about these issues. But at the end of the day, sometimes just burying the issues and not openly acknowledging them allows them to become a bigger distraction than they need to be. Sometimes a simple direction from management. We understand that this horrible event has happened in the world. We understand this may have a disproportionate effect on certain members of our community. They have our full support, but we ask everybody to, et cetera, et cetera. So sometimes you need to just hit the nail squarely on the head and move forward to keep people focused. Have an open door policy. Listen to your employees, take concerns seriously. If somebody comes in and says, I am of Russian descent, I have family in Russia, and so is saying X, Y, Z about Russia's invasion of the Ukraine, then you need to hear them out, and you need to make sure that the differences in belief or opinion there are not resulting in some form of prohibited conduct, such as workplace harassment. You also need to engage with staff. As I was saying, you need to acknowledge those dumpster fires. You need to acknowledge trauma. You need to know who is going to be disproportionately impacted by world events and give them your support. If somebody had family in Israel on October 7th, 2023, those are people who are going to need some support from the organization. Trauma is trauma, regardless of where your views lie. Okay, and you need to be prepared to accommodate individuals who may be more impacted. And that doesn't mean giving them a pulpit from which to scream at their colleagues, but it does mean treating everybody compassionately, ensuring employee assistance programs are available, and providing other resources to assist people who may be suffering. And don't allow your policies to be weaponized either, okay? If you have an anti-harassment, respectful workplace policy, it's a shield, but it shouldn't be a sword as well. At the end of the day, what we want to say is we can't avoid these conversations. They're going to happen, so don't be afraid of them. You need to hit them head on, and you need to manage it and create a workplace culture where people understand that everyone is going to have an opinion. We may have differences of opinion, but it's how we express them that matters. And then at the end of the day, this is a workplace, and productivity and the ability to move forward and get our jobs done is important. Conflict is normal. Conflict is inevitable. We're going to disagree about everything from the use of an Oxford comma to, a global conflict. It's all a matter of how we manage it, whether we're willing to address it, and how we keep people focused on the task at hand as opposed to becoming distracted by what's, this dumpster fire of current events. And that's it at a very high level. If you have any questions, don't hesitate to put them into the comments. We'll do our best to address them. And we're always available, of course, after the webinar to help you further should you need it.
Thank you, Dana. I'm going to turn it over to John Ward now from our Calgary and Vancouver office to speak with us about navigating mutual exits, the when and the how. Over to you, John.
Thanks, Leslie. Good morning. Today, I want to talk a bit about mutual exits and where they can work really well, because they can be a really useful tool. So if we pop over to the next slide, I want to start with what is a mutual exit, and really it's the same thing that we do when we settle a termination on the back end by agreeing to pay X dollars in exchange for release. But we get to that point through a bit of a different way, and context depending, they can be a really great way to get there. One practical takeaway to flag is that you need to get the release. So you agree to a mutual release on the front end before the cessation of employment takes place. But you need to get that release on the back end after the termination or the resignation occurs. There's a general argument against enforceability of releases that purport to release future events. So if you agree to a mutual separation and there's a working notice period, employees subject to some egregious harassment during that working notice period, that's not contemplated by the release. So one really important practical takeaway is that you want the release post cessation of employment. So if we jump to the next slide, the biggest pro or advantage of mutual separation agreements is flexibility. And so a great example here is, are we calling it a termination, or are we calling it a resignation? And this is such a useful toolkit, because there's a lot of emotional value in framing a cessation of employment as a resignation where that matters to the individual. So don't make it a unilateral, you're not good enough kind of discussion, but bring them into the tent with you and have that discussion so that everyone can be a little bit more amicable in discussing the separation. I know we all have our working notice horror stories. I certainly have a few. So working notice isn't always all that great, and it can create problems. But in the context of succession planning, mutual separation agreements can be really great, because you can, again, have an amicable discussion. You can have certainty as to the runway and pass that baton for contexts where that's a good fit. Also really useful for complex compensation, bonus entitlements, equity entitlements, option entitlements, things like that. Have those discussions about really complicated sets of compensation when everyone's on a little bit better terms than after a termination that may come as a surprise. This one is my most, I think the best factor in favor of mutual separation agreements, give the employee agency. So I think there's so much value in having them feel like they're a part of the discussion in a cessation of employment. Again, where the context works, but when it is a good fit, it just ramps down the intensity of what can be a really sensitive discussion. And they're really proactive. So I like to say we're playing with a loaded deck. We're discussing the terms of the separation before we've pulled that irrevocable ripcord. And so there's a ton of value in approaching things that way. Turning now to the disadvantages here. Fair warning, they can backfire. They're not a silver bullet. Sometimes they can be, but not always. And so the most important thing here is assess the personality of the individual you're looking to separate. And this is not always necessary, but I think it's such an important piece and can be so integral for these going really smoothly. Do you have someone on your team who has a really good relationship or really good rapport to broach the issue? Because so much of this is framing. Where it backfires, it's going to be in oftentimes in the vein of, you're trying to push me out, this isn't fair and reasonable, and it just kind of, the whole idea is that it's less acrimonious, and sometimes when it backfires, it becomes more acrimonious because they feel like you're being sneaky about trying to separate. And so having that person with good rapport is just really valuable. In the vein of these disadvantages, the biggest thing is you can't put the cat back in the bag. So once it's out there, you can smooth things over, but you're never going to be able to turn back the clock. And so you need to be live to that in assessing the individual. It's not always a massive issue, because sometimes a mutual separation agreement is a prelude to a termination. So we know we're going to terminate. Let's take a run at the more amicable, easier discussion. And if it doesn't work, then we'll proceed with a termination. The legal risks fall into two main buckets: constructive dismissal. This is in the vein of evil, nasty employer tried to push me out with a package. How could I possibly return and manage my team when everybody knew that I was on the chopping block? And then from a human rights perspective, typically we'll see these more where there's a concern about a human rights complaint because an ounce of prevention is worth a pound of cure. What you need to be live to is creating bad facts in the vein of, I have a disability, my employer learned about that and tried to push me out, and here's the example, they talked about this mutual separation. So be hypersensitive to that potential bad fact. In looking now at common scenarios, these are kind of the situations that we see where when this fact pattern comes before me, I'm immediately going to, can we try and make a mutual separation agreement work? This first one is one that I see all the time. And so employee A is, solid 6 out of 10, serviceable but not great. They go on a leave and someone comes in and they're a rock star, and you really want to keep employee B. There are no silver bullets in what we do, but sometimes this can be a silver bullet. And so where I've seen this work before, a particular example, new parent goes on leave, rockstar employee comes in. If you have that person that can broach it with them, I've seen this well and truly turn into a win-win, where employee on leave is like, you know what, I didn't really want to come back anyway, take a chunk of change, have a little bit more time with my little one. And it's a win-win, which is so rare. And it just feels amazing when you shoot the lights out with those. A long-term employee looking to retire, this is like you have a pending retirement, and really what you're looking for is certainty as to the runway to succession plan appropriately. So here, the biggest one is give the employee agency, bring them in, have a mutual discussion. It's not a unilateral discussion regarding timing, and that lets you plan. And then what I've seen before is it helps the individual who's retiring is that much more invested in that passing of the baton and training up, because they've talked about it with you, and it doesn't come as a unilateral, or you're not surprised on, a month's notice. This last one makes me chuckle because I always think about the big personalities, the 10% of employees that take up 80% of time and energy. If you have a really challenging individual and they're not averse to conflict, this can work. Now, this is going to be the prelude to termination stream. We kind of know there's got to be a separation, but if you can frame it in a way that makes them feel like a winner, you can save yourself so much time, energy, and headache because you lowball and let them grind you up, and they feel like they've put one over on you because they went from 2 months to 6 months, but really it was a 6 to 8 month notice range anyway, and so you're perfectly happy to package them out and have it not involve a bunch of litigation. So that's a kind of 50,000 foot view on mutual separation agreements. So I'll throw it back to Leslie now.
Thanks so much, John. That was great. And I think, a lot of those common scenarios sometimes are a bit murky, as John mentioned, because of potential human rights aspects. So it's always better if you have, to John's point, a sophisticated person who can coax the idea about these initial discussions from the employee themselves. So really appreciate that, John. Next, we're going to have Jen and Kate, associates in our Toronto office, speak with us about exceptional notice periods on termination and touching upon inducement, long service employees, and other various factors.
Hi, everyone. I'm Kate, and together with my colleague Jen, we're going to discuss exceptional notice periods on termination. As a quick agenda, we're briefly going to review what notice periods are, and then go into a discussion about circumstances when notice periods are extended beyond the norm. So this includes inducement and exceptional circumstances, such as the termination of employment for extremely long service employees and some other examples. Okay, so notice periods. A notice period is the amount of notice or pay in lieu of notice that an employer is required to provide to an employee when their employment is terminated without cause. There are statutorily prescribed minimum notice periods in all jurisdictions across Canada. To limit an employee's notice entitlement on termination to those minimum statutory requirements or to a greater contractual requirement, you need to have an employment agreement in place that contains valid and enforceable termination provisions. If there's no valid and enforceable employment agreement, the default entitlement for employees terminated without cause is common law reasonable notice. Common law reasonable notice, it's assessed based on factors specific to the individual employee, with the most common factors that are being weighed, including the employee's age, their length of service, the characteristics of their employment. So for example, their compensation, whether their role is highly specialized, is it managerial, how senior is the role, as well as the availability of similar employment. These are typically referred to as the Bartle factors, and that name comes from a case from 1960. And generally, the purpose of common law reasonable notice is to provide the employee with a reasonable period of time to allow them to obtain new employment and mitigate the impact of job loss during that period. You'll often hear it described as an art rather than a science. It typically works out to 3 to 6 weeks per year of service, but that is by no means set in stone. For some employees, reasonable notice is disproportionately high. For example, employees of more advanced age, of longer service, with higher compensation and senior roles, highly specialized roles, they will typically be entitled to a greater amount of notice, as generally it takes them longer to obtain new comparable employment. Short service employees as well, they typically receive disproportionately high notice periods just because it takes time to find a new job. So, for example, if an employee is terminated after 2 weeks of work, it may still take them 2 to 3 months to look for and start a new job. There's no maximum, but it's unusual for reasonable notice to exceed 24 months on the high end, except in exceptional circumstances, which is what we're going to review with you today. So inducement, this is one special circumstance. So it's a particular situation where an employee leaves relatively long-term, secure employment and is terminated from new employment relatively quickly after being hired. It's intended to operate as a safeguard against the employee's reliance on promises that were made to them during the recruitment process. But to constitute inducement, the employer's conduct has to go beyond the ordinary degree of persuasion. So for example, if promises of career advancement and job security are made, or not, if an offer is made that's too good to pass up, like if there's a significant increase in compensation and responsibility. So to provide a real life example, we have a case called Useni and Cas Mineral Projects from British Columbia. So in this case, the plaintiff, Useni, was terminated from Cas Minerals 3 months after being hired. He had an employment agreement, provided him with 1 month of notice on termination. The court found that the termination provisions of the agreement weren't enforceable, so the default, of course, common law reasonable notice. Based on an assessment of the Bartle factors, he was entitled to 4 months of notice. This is another good example of a short service employee being awarded a disproportionately high amount of reasonable notice of termination. The court also found inducement, and as a result, they increased the notice period by 2 months for a total of 6 months. So how did they find inducement? He was securely employed for 2 years before joining Kaz Minerals. He was recruited by Kaz Minerals. They pursued him through LinkedIn as opposed to the plaintiff applying to an open position with the company on his own accord, for example. The interview process was extensive. There were 4 separate meetings. And finally, Kaz Minerals designed an irresistible offer. Having regard to the plaintiff's circumstances, they gave him an assignment based in Vancouver on a major project and increased his vacation entitlement and substantially increased his salary. The court found that that went beyond standard wooing. Next slide, please. So how do we reduce the risk of inducement when we're recruiting employees? So when balancing whether an employee is entitled to enhanced notice as a result of inducement, the following factors could help support an argument that the employee was not induced. So 1, if employees are not targeted and sought out, but apply to positions independently. 2, the company does not meet the specific demands of the candidate, for example, if they're negotiating certain bells and whistles, and if the company refrains from crafting an offer that's impossible for the candidate to resist. 3, an employment agreement, that's a valuable tool. We can put in language that clearly sets out that there's no promise or guarantee of long-term employment. Having a probationary clause is very helpful because that implies that employment is tentative. And having enforceable termination provisions is very important. And then as well, the longer an employee is employed by the new company, the weight that is given to inducement will be less. I'm gonna hand it over to Jen now.
Thanks, Kate. So Kate's now taking you through inducement, which as mentioned is more of a greater risk at the start of an employee's employment. So, the longer an employee has stayed in a position, the less of the risk that inducement will come up because they've already kind of gotten the benefit of that new job. Now, conversely, when you look at long service employees and other exceptional circumstances, this poses a risk later on in the employment relationship. So you're never safe. So when determining reasonable notice, in addition to the Bartle factors Kate discussed, courts will also consider any exceptional circumstances that may justify extending the reasonable notice period for the employee. These exceptional circumstances may warrant a longer notice period for employees and may even lead to circumstances where the employee is awarded more than 24 months. The Ontario Court of Appeal has said that there's no absolute limit and cases must be determined on a case-by-case basis. So historically, we have seen circumstances that might result in a longer notice period, and one that exceeds 24 months is an extensive length of service, senior executive and highly specialized roles, and individuals nearing the end of their working lives, because these factors have been determined by the courts as likely to impact the employee's ability to find reemployment or comparable reemployment, which is the key factor. So there have been 2 recent decisions in Ontario at the Court of Appeal level that have found the 2 employees impacted by their terminations were entitled to notice periods exceeding 24 months. So we're now looking at this in the vein of, are the exceptional factors still what the courts have already or have always said that were exceptional, or are we finding some cases it's not as exceptional as it used to be? So the first case is Lynch, which the Ontario Court of Appeal looked at. And so Lynch was a professional engineer, 38 and a half years of service with the same company and 64 years old at the time of termination. He was awarded 30 months of common law reasonable notice because he didn't have an enforceable employment agreement, so it defaulted to the common law. And the main factors that the court considered when reviewing Lynch's circumstances that resulted in him being awarded more than 24 months was that Lynch had a very unique job that was specialized. And in this case, the employer didn't contest that the employee was very specialized, and the design of the software to control, he was designing software to control unique hardware manufactured by the company in its Belleville, Ontario facility that wouldn't be applicable elsewhere. During each year of employment, Lynch developed 1 or 2 patents for the company. He was a key performer, and similar employment specifically in Belleville wasn't going to be readily available to him, which is where he lived. So we still see that those factors is he did have an extremely long service. He was older, and then they really focused on this case. And in the next one for Millwood versus IBM on, I think, the unique character of the individual's job. So they're doing their skills that they've developed over their long career are not going to be applicable. And so you'll see here the facts are very similar: 62 years old, 38 years. And in this case in particular, they did factor in COVID-19, which is significant because now that we're out of COVID-19, hopefully, we can all say that, you know, COVID-19, we actually saw a huge boom in the job market. There was a lot of flexibility, a lot of especially software jobs open. And now in all the demand letters, we're seeing people saying, we're in a recession, the COVID-19 boom is over. Now is actually the exceptional circumstances. COVID-19, that was the good old days when you could move around. So it really is this fluctuating. Every single demand letter is going to say the economy is terrible, and you have to respond to that and say, no, please, it always gets better. The court said it was tantamount to a forced retirement. So I think that's where you look at the long service, the specialized role that he was doing, and the tenure that he had and age, that the court found that the likelihood of him finding reemployment was just non-existent. Okay, but we've also seen recent cases where decisions or the job will not warrant exceeding 24 months. So we have 2 decisions I put up here where the individuals, again, had long tenures that exceeded the 24 years. They were older. So the first individual was 59, the second was 65. And in both cases, the courts found that 24 months was justified in this situation. But I will say both of these individuals didn't have that kind of unique character that the last 2 individuals had in their job, and the skills were more applicable broadly in the economy versus someone working on software that could only be applied in their own workplace. Okay, so final takeaways. What is considered an exceptional circumstance may be becoming less exceptional. However, if you're not having a technical role, I think that is where we're really seeing the risk right now. If it's a broader kind of role description, it's still arguably not exceptional. And then you have to look at the longer service, the age of the employee, and those other Bardell factors. The forced retirement is where the exception is found. And then you always have to keep in mind that reasonable notice period is subject to mitigation. So an employee that is claiming 30 months, they have 30 months then to find a job. And so it might not be a situation where you would like to agree to that right away. You might want to say, you know, we'll see how this runway works and see what you find during that time.
Thanks so much, Jen and Kate. For our last presentation here, I'm going to turn it over to Shalini and Connor, who are going to provide us with some legislative updates in Canada.
Thanks, Leslie. Hi, everyone. Connor and I will start off with some proposed changes for our federally regulated clients. I will then move on to the legislative updates in Ontario, and Connor will conclude with BC, Quebec, and the Prairies. Connor?
Thank you. So as most of you likely know, the federal government released its budget in April of this year, which proposed several changes to the federal employment laws, one of which was an announcement of an intention to amend the Canada Labour Code to establish a right to disconnect. However, the proposed amendments that were subsequently released in the Budget Implementation Act do not actually mandate a strict right to disconnect. Rather, if passed in their current form, the amendments would introduce a requirement that employers merely implement a policy on disconnecting from work. So in addition to the policy requirements that you'll see on the slide there, the proposed amendments will also impose various duties on employers with respect to the timing of the policy implementation and updating it as well. In addition, there's a contemplated 90-day comment period to consult employees. These proposed amendments are similar to what was seen in Ontario with the policy implementation, as opposed to imposing the strict right to disconnect. And essentially, the amendments are designed to inform employees of what the organizational approach is to disconnection and what the expectations are of their employer. Next, the federal government also proposed amendments to improve job protections for federally regulated gig workers. So these are individuals who enter more casual work relationships, such as short-term contracts with firms or individuals to complete specific and often one-off tasks. They've done this by proposing to increase inspections and enforcement efforts around classifications. The amendments would make it an offense to treat an employee as if they were not an employee, and it would also allow employees to make complaints where they believe they have been misclassified. One of the interesting elements of the proposed amendments that appear to broaden the scope of the announcements in the budget is that it would introduce a reverse onus under the Canada Labour Code, where there is a presumption that any person who is paid remuneration by an employer is an employee unless the employer can prove to the contrary. So this reverse onus increases misclassification risks, and federally regulated employers would be well advised to review their independent contractors and consultants if this draft legislation is passed to ensure that the misclassification risks are minimal. As well, there are other various technical amendments to the code, such as the time limit for filling vacant health and safety representative positions. There's also a clarification around the ability of the Canada Industrial Relations Board to make certain orders in the context of unjust dismissal complaints. And lastly, the budget reaffirms the federal government's commitment to the ban of replacement workers. This was further to a bill introduced in November of last year, and we expect the government to continue its efforts to pass legislation in this regard. So in addition to the Canada Labour Code amendments, there was also proposed legislation around the forced labor and supply chains. This is also further to legislation that was passed last year, in which certain companies were required to submit a report by May, by the end of last month, which identify the risks of modern slavery in their supply chain. So these announcements signals an intention to introduce new legislation or to amend the legislation that was introduced last year. And finally, there was proposed amendments to the Employment Equity Act. They did not specify the expanded designated equity groups, but previous announcements indicate that the two new designated groups may be created for Black people and 2SL GBTQI plus people. While these proposals were not included in the Budget Implementation Act, there have been recent announcements that the consultation process with respect to the Employment Equity Act is still ongoing, and they're inviting input on the current state of the Act to move forward. So we actively encourage employers to monitor the evolution of the budget and its announcements and the employment-related initiatives that come out of it. So with that, I'll turn it over to Shalini to take you through the Ontario updates.
Thanks, Connor. So Bill 149, the Working for Workers for Act, was recently passed by the Government of Ontario and created some new and significant responsibilities for employers. The most significant amendments relates to employers' obligations regarding recruitment and job postings. Specifically, public advertised job postings will now be required to 1, disclose the expected compensation or the range of expected compensation for the position, and 2, disclose the use of AI to screen, assess, or select applicants. Employers will also be prohibited from including any requirement related to Canadian work experience on the public job posting or the application form. These changes aren't currently in effect, but are expected to come into force sometime in the future. A change that has already come into effect is the expansion of the definition of employee to include work performed during a trial period. This means that when an employee is training, they will still be entitled to minimum standards under the ESA, such as minimum wages, hours of work, and vacation. Other changes that have come into effect or will be coming into effect in the next couple of weeks generally impact restaurant and service industry employers. For example, employers cannot deduct wages from an employee in a dine and dash scenario, and there are some additional changes coming soon regarding the payment of tips and tip pooling. A significant amendment that is taking effect on June 21st is regarding vacation pay. As of June 21st, a written agreement will be required if you want to pay vacation pay at a time other than when the employee takes the vacation time. So if you pay vacation pay on each paycheck instead of when the employee takes their vacation time, you'll now be required to have a written agreement with the employee to do so. So the next bill that was introduced this year is Bill 190, the Working for Workers 5 Act. Similar to the other Working for Workers Acts we've seen in the previous years, Bill 190 proposes several amendments to the ESA and the Occupational Health and Safety Act. So in addition to what I mentioned earlier regarding disclosing the expected compensation for the job and the use of AI in screening, assessing, and selecting employees, Bill 190 takes it one step further and requires employers to disclose if the position they've posted is actually vacant. It also prevents employers from ghosting potential candidates. So if you've interviewed a candidate that you don't want to proceed with, you would be required to let them know that. Other changes that would be proposed by Bill 190 are prohibiting employers from requesting sick notes from a doctor in order to take sick leave under the ESA, and doubling the maximum fines for individuals convicted of an offense under the ESA from $50,000 to $100,000. In order to address the increase in remote working arrangements, the Ontario government is also proposing amendments to the Occupational Health and Safety Act. Specifically, Bill 190 proposes to expand the definition of workplace harassment and workplace sexual harassment to expressly apply to harassment in a workplace that occurs virtually. So what Dana mentioned earlier regarding the concept of a workplace being very broad, this express addition to the definition of workplace harassment and workplace sexual harassment will add to that. The proposed amendments would also allow employers to post information they are obligated to post in the workplace electronically. And finally, as most of you know, many employers in Ontario are required to have joint health and safety committees that meet at least once every 3 months. So Bill 190 proposes to allow these committees to meet remotely instead of at the workplace. Now, Bill 190 is currently in its second reading. We're unsure of when this bill will get passed, but we'll continue to monitor for updates. Now I'll pass the torch back on to Connor to discuss updates in BC.
Thank you. So I'll very quickly run you through some updates in BC and the other provinces. So first of all, in BC, there was an amendment to the Employment Standards Act to provide for an automatic adjustment to minimum wage rates based on the Consumer Price Index applicable to BC as posted by Statistics Canada. One of the more interesting ones was a recent bill that was passed to define the definition of strike under the Labor Relations Code, which would allow provincially regulated unionized employees to refuse to cross federal and other non-BC provincial picket lines without it being considered an illegal strike action. So if your business operates in BC with only an indirect connection or even no connection at all with a federally regulated business, then your business could still be hit with a federal picket. While this legislation was passed, it has not been proclaimed into force as of yet. And then in Quebec, very quickly, there was changes to the workplace psychological harassment legislation, as well as changes to the license renewal process for placement agencies. And you can go to the next slide as well. With any of these other provinces, Quebec, Manitoba, Saskatchewan, if you have any questions about the recent legislative updates, you can reach out to our colleagues in those jurisdictions. But in Manitoba, there was a new general holiday recognized. The interesting piece about this one is that unlike other holidays, the Orange Shirt Day, which is on September 30th of each year, cannot be substituted for another holiday. There were other proposed amendments as well, including substantial changes to the Labor Relations Code and the Labor Relations Act and the Employment Standards Code. And then finally, our colleagues in Saskatchewan have let us know of a potential overhaul of the employment legislation in that province. The public consultation process from the Ministry of Labor concluded in October of last year, and they expect significant changes to occur this year or in the coming months. So we will keep everyone updated on those fronts. And with that, I will pass it over to Leslie, and if we have any time for questions, then we'll do that. Thank you.
Thanks so much, Connor and Shalini. Maybe we'll take the last couple of minutes here to run through a couple of the questions that we received. One question we received was about employees who are prepared to consider a voluntary departure package and resign from their employment, have concerns about eligibility for EI benefits, and how can a mutual separation impact that? So that's a question that we received quite a bit, and then I'll let John weigh in on that as well. But typically when you resign from your employment, in most circumstances, an employee will not be eligible for EI benefits. So sometimes what we'll do is recommend structuring it as a mutual ending of the employment. So you don't necessarily use the word resignation, but it's enough that you can indicate that you might code your ROE with code K for other and indicate that it was a mutual ending of the employment relationship. In that instance, we typically recommend that at least the amount that's being provided to the employee in exchange for release slightly be in excess of the statutory entitlements, because in that instance, it's not ultimately going to be characterized as a resignation. Another question that came for you, John, was about how do you get someone to sign off on a release at the end of a negotiated notice period?
Yeah, no, and so that's a great question. So what you do is you agree to all of the terms prior to in most instances, prior to the cessation taking effect, and then within the agreement, you build it. So cessation of employment, receipt of release, payment. And so the carrot is still there with the dollar figure, but so in terms of timing, it's directly analogous to how a termination usually unfolds. But the key difference is that everyone signed on the dotted line regarding the entitlements that are going to flow both ways. And so you don't negotiate after you've pulled that irrevocable and unilateral ripcord of terminating.
Thanks, John. And Dana, then we have one question for you as well. And the question was, what to do when an employee wears a political pin or some other expression of a political statement on their clothing? In that instance, if they're not speaking about it or otherwise making remarks in the workplace, but there's a general concern that perhaps this will impact customers if this is an individual who's engaging one-on-one. What are your thoughts on that part of it?
Well, I think step one, you want to look at your policies. So, sometimes an easy workaround this could be a dress code policy. Do you have a requirement that employees refrain from wearing certain types of personal adornment, right? Which could potentially cover the issue of a pin. Of course, you also need to look at whether you're in a jurisdiction where there is human rights protection afforded to political expression. But again, you still have that bona fide occupational requirement to look at. And if your position as an organization is that you're not taking a position on a particular issue and you have employees who are responsible for client interface and they are there representing the organization, then you can rely on your policies regarding dress codes, solicitations, communications with client, whether they're verbal or nonverbal communications, to rein that in. The challenge is if you have an employee who is particularly difficult, and honestly, you have to treat those ones on a case-by-case basis, taking into consideration whether there are human rights issues, or if the employee is ultimately engaging in conduct, that is insubordinate or potentially constitutes harassment, which of course doesn't have to be verbal.
Yeah, it's interesting, Dana, because I think more and more people are trying to streamline their policies, but then suddenly you see where the value of a dress code policy can really come in, right? When you're preparing your dress code policy, you may not be thinking or anticipating about this instance. And then our final question for today is for John. John, the question was about what happens when an employee comes forward to ask about separating from their employment. What's kind of some guardrails on how to handle that?
Yeah, so I think that's going to really depend on what you as the employer want to do. So if they're a great employee and you're fine keeping them, then I think you would say, well, no, not interested, thanks. But if you'd like to resign, here's kind of the timeframes and the expectations. If you do want to separate, then that's perfect because it segues seamlessly into the mutual separation discussion, which is going to be way more efficient and less disruptive and acrimonious than it would be to do it unilaterally. And I think it kind of highlights just when the context fits, it's such a great way to button up the separation, because you negotiate on the front end efficiently and while everyone's still on pretty good terms.
Thanks, John. All right, everyone. Well, that takes us to the end of our webinar for today. Thank you so much for attending and your participation. As I mentioned, the slides from the various speakers' presentations will be circulated by email following this presentation, and I think there will also be access to a video link of it as well. Have a great day, and thanks everyone again. Bye now.